Next is harmless error. Okay, this was also a 1984 case. This is the one that I kind of got confused last class meeting when I was trying to describe the Leon case to you. I was actually reporting to you the findings in the Massachusetts versus Shepard case. So let me share that with you real quick to correct the record completely. Okay. In this case, the Supreme Court held that evidence obtained by the police as a result of serving a search warrant in good faith is not to be excluded simply because the warrant is technically flawed. In the case, police officers used an incorrect warrant application form, then altered the form so that the judge would authorize the search. The judge authorized the search, assuring the officers that the necessary clerical corrections would be made. So you kind of have to use your imagination how this worked out. The police want to get a warrant. They pull a form out of the file. This is in the days before computerized things, right? There were computers, but the police department typically would not have had this kind of computerized process. So they reach into a file cabinet and pull out a pad of forms and scribble out the information, not noticing that they had gotten an incorrect form. They take that to the judge. They say, "Oh, Judge, our apologies, we got the wrong form, but we really need to execute that warrant right away." And the judge says, "Okay, don't worry about it. My staff will fix it." Okay? But you have to understand, before 1984, and I think you saw this a little bit with the panel discussion that we were watching, the exclusionary rule was pretty much treated as a prophylactic remedy. That is to say that any kind of problem with the warrant would mean that it would automatically be excluded at trial. And that's a big part of what they were debating in that panel program is, should it be automatic? Well, here you have in 1984, in addition to the Leon decision, you have this case, Massachusetts versus Shepard, which said, we're not going to punish the police because the judge never got around to instructing his clerk to change the form. Or maybe he did, but the clerk did not do it, didn't execute that job function. All right? We're not going to punish the police. They were serving that warrant in good faith, and so therefore the evidence does not have to be excluded at trial. The Supreme, yeah, go ahead.
Just all these little things we got here, it sounds like they're really trying to get you. Like, doesn't it sound like they're getting the police more powerful to get you and be a little bit safer on the fact that they got you?
You know, I've said a couple of times that tried to describe it as a pendulum, you know, where from the 1960s through the mid 1980s, you kind of have the courts, the Supreme Court in particular, really sort of going the extra mile to protect the rights of the accused. And then beginning in the mid 1980s, you see the pendulum begin to swing the other way. But I didn't really offer an explanation to you for maybe why that, other than to say that the Supreme Court now had a pretty clear conservative majority. But I think beyond that, it probably merits saying that, you know, there was a perception on the part of many people in law enforcement and in the legal profession, certainly among prosecutors and maybe judges as well, and certainly in the general public, that the explosion in the crime rate that we saw in this country beginning really in the late 1960s through the 1970s and through the 1980s was a direct result of coddling criminals. There was this very widespread perception. I think political conservatives had definitely had a rhetorical edge in this debate over the rights of the accused. They would argue things like, see what happens when you coddle criminals? When you make it easy for people to get off on technicalities, you get the murder rate explodes, the violent sexual assaults explode, other sort of personal assaults explode, property crimes explode. There's no question that the crime rate in almost every category of crime grew dramatically from this very period that we're talking about, from the 1960s through the mid-1980s. It is also undeniable that on many indicators, the crime rate came down in the 1990s and through the 2000s, and you know, for example, the murder rate in most American cities, like take the city of Houston, is much lower today than it was in the 1980s. I don't know how many homicides you have annually in the city of Houston. I'm going to guess it's probably somewhere around 500, but back in the period that we're talking about here in the 1980s, it might have been up around 800 or 900. You know, I mean, it's just absolutely clear. What's not as clear is the cause and effect. Okay, there's, you know, lots of good room for debate on the cause and effect, but the fact of the matter is that in politics, the conservatives seem to have the edge in this argument. They were saying it's because of these lax decisions of the courts and coddling the rights of, they would probably say, the rights of criminals. I think more progressive people who are more politically progressive would probably say they're not coddling the rights of criminals. They're coddling maybe they're trying to protect the rights of the accused. Remember that in our criminal justice system, being accused of something doesn't make you a criminal. In fact, you are a citizen until you're proven guilty, right? With full protections. I think that's an argument that the conservatives, at least in terms of the political debate, prevailed on. Okay, good question though. Let's see, was there a point here we needed to touch on? Let's see. The Supreme Court reversed the suppression order, ruling that the error was harmless. And again, I think the defense attorneys would say, not to my client, but was harmless, and in any case was made by the judge and not the police. In a similar vein, the Supreme Court has ruled that the exclusionary rule does not apply when the police, through an honest mistake, find drugs while searching the wrong apartment, or where a computer error showing an outstanding arrest warrant on the wrong person leads to a search of a vehicle that turns up evidence used to arrest and convict that person. So there's another little caveat kind of to your question, Doreen, a circumstance where it might be. Okay?